Can you hear me? Oh, Yasmin can hear me. Okay. So I was just actually just saying thank you for coming back and being energized now after this break. And we will resume with the some online questions first, and then we will give the microphone to so an online question and an in-person question. So I'll first start, and first of all, I have to say Dr. Ismail had to leave for an important appointment, so that's he's not with us right now. We do thank him for his participation. So I'll start with the first two online questions to Yasmin and Anne. They are more of a procedural question, interesting questions. The first one is by Vincent, says, what happens where one of the dispute board members resigns before the completion of the project, where the DB had been constituted? Can the parties appoint another? And if yes, how efficient the new member would be when resolving the dispute? The second question, I'm just going to take those two questions and we'll answer them, Yasmin and Anne. The other one is, if a DB is unable to resolve a dispute and it gets too much time in resolving the dispute, can we change the DB members entirely during a process? If yes, what is the procedure? Please go ahead. So
Okay.
you can change. You can choose Anne and Yasmin, who would respond to.
Yeah, for
Yasmin,
sure.
would you like me to talk maybe globally, and then you could bring it down to practically how it works in the region?
Yes.
So,
for sure.
okay, great. So I will say that I do have a manual that's available for a free download, and I encourage everyone to go to our website, drb.org, and do that. We have a whole chapter on replacement of dispute board members. There can be various reasons why someone may leave a dispute board once it's underway. Sometimes it could be an innocent issue like a health reason or something like that. New disclosure issues could come on the scene, and maybe while someone did not have a conflict that impacted their impartiality at the start of the project, if one were to develop, there is that continuous need to disclose throughout the life of the project, and that might result in someone needing to step down from the board. Resigning from the board or replacement is always something to be done very cautiously. As is referenced in the initial question, replacing someone mid-project then has the unavoidable result of having lost the dispute avoidance and expeditious resolution that occurs when someone is following the project from the beginning, getting to know the parties, developing that trust, and resolving issues before they become disputes. So it should be taken very carefully, but if it does occur, then yes, there is an opportunity to replace a board member. I think maybe Yasmin can talk more about this, but it's ultimately, I think, going to come down to what the contract says about replacement or the rules that are in place for that particular project. Often people go back to the initial way that the board was constituted. So whatever your selection method was from the beginning, you go back to that same selection method for a replacement. So those are my general comments about the replacement. And I guess maybe just to add on, it's really going to be incumbent on the chair to bring that new board member up to speed on the project so that they can, catch up very quickly and continue those benefits of working together as a panel. So that would be my comments on those two questions. Yasmin?
Thank you, Anne. Nothing further, really, just a couple of perhaps notes from the practice so far. The two questions may be evaluated together, perhaps. Yes, replacement is possible. In case of resignation, as the relevant document is the dispute adjudication agreement, and it is possible for the dispute board member or the dispute board to resign. So it's effective and it's a unilateral right. However, it doesn't work vice versa. So it means that, for example, in the second question, it was asked whether it is possible to for a party to replace them. It wouldn't be possible unilaterally to end a dispute board agreement. It will be only possible with the agreement of the employer, and the contractor. So in order to ensure that this is not abused as a process of hindering the process. However, from practice, how it goes, of course, a number of events may happen and they may be natural things. A new conflict may have arisen, a change of place may have taken into account, and then also medical problems. In case it's a standing board and there is already a working cooperation between the board members and also between the board and the parties, what I have seen so far is that the trust is created, so the suggestions by the current remaining members of the dispute board would be taken into place, and in most of the cases the remaining board members will try to replace with agreement on a common name, and they are also able to convince the appointing parties to for the suggested names by the remaining members. It is more difficult in case it happens, especially in the middle of a referral, in an ad hoc process. And that is definitely not the best case scenario. And there is no shortcut to overcome the obstacles, because it will probably entail a postponement of the whole term, and also the remobilization of the new member to the dispute. And so it is not going to be an easy process for sure. And a last remark on the second question is that in case the decision, so the dispute board is late in rendering the decision, that decision is not properly issued as per the contract regulations. Therefore, any of the parties may object to the decision, firstly. Second, it also constitutes a failure of the dispute board warranties to the parties, because the dispute board with the DAA, Dispute Adjudication Agreement, undertakes to be available, to be promptly giving the decisions, recommendations, or even making the site visits accordingly as per the contract terms. Therefore, in case a board does not render a decision timely within the time limits, it also fails to comply with the DAA. And that is a reason to start the specific board members' default, which I have also seen, of course, not directly so far, but in cases where, more or less we have encountered as party counsel. So overall, it's part of the life. So things may happen. There are a number of contractual provisions to deal with, and there is certainly a practice grown sufficiently, especially where the board is standing mode.
Thank you very much. Does anyone from here have a question to pose? So since we took two questions live, virtual, we'll take two questions live. So, Shagil? Yeah. That's a loaded question. I'll just take the second half and the first half of enforceability. I think maybe Yasmin, we can share that one because that's a very common topic that we encounter in the DRBF, and we've also so in terms of the candidates, as you say, or the dispute board members, they can, like Yasmin mentioned, the dispute board is really a creature of the contract. That's the beauty of a dispute board. So any members or people that the contracting parties trust in rendering decisions to their disputes. So you can have definitely, say, for example, I mentioned the project that I said that was there was here in Egypt that had a lot of disputes, and then it ended in a resignation of someone, and so that panel that dispute board panel had a judge, for example, who's very well versed in governmental law. It had an expert, huge expert in FIDIC contracts, international expert, who had to fly into Egypt, and who has books on FIDIC, and it had an also expert engineer arbitrator in Canada. So in other situations, say for example, you have a project that is specialized in geotechnical works or something, you can have a geotechnical, there is no rules per se. So you can have lawyers, you can judges, you can have but of course the trick is they have to be also well versed in contract, some in the law, but they can be actually the conference that we had a conference in Istanbul in 2023 November, and actually one of the things that our Libya contract representative from Libya said, one of the challenges in Libya is that they sometimes would get members who are they're just technically qualified in a certain topic, but they don't have the legal or contractual thing. So that's not good as well, but it's good to have a balance. But yes, the answer to your question is, yeah, of course, they can be anything that can help, any competency that can help resolve the disputes. This is really the issue, resolving the disputes, avoiding the disputes. Regarding the tricky topic of enforceability, and I would say you're taking legal enforceability, of course, right?
Say enforceability in general, the parties are in conflict and they have reached the board for resolution, and the decision is made.
Yes.
If one of the parties is not extremely happy with that decision.
Okay, so let's separate between contractually and legally. Okay, so for the FIDIC contracts, when you have a dispute adjudication board, like I said, in the States, it's a review board. That's a different issue. Adjudication board, by contract, the decision is binding, even if a notice of dissatisfaction or rejection or objection is sent within 28 days. If it is nothing is sent, then it's not just binding, it's binding and it's final, which means that even if they go to arbitration, the arbitration panel is going to say that contractually you guys agreed that the decision is final after 28 days pass with no objection. So we don't have an authority to give a decision here, because you've agreed in the contract that it's final, so you shouldn't. But binding alone just means that until they go to arbitration, so for example, as you said, the engineer made a determination, the dispute board changed the determination. So the engineer's determination is binding until the dispute board issue a award. Okay, then it's binding until it goes to arbitration. If one of the parties, just as you mentioned, which is, as we also mentioned here, Mian mentioned this point several times, and we touched on this. It happens sometimes. The employer says, "No, I'm not. I don't care what the contract says. I'm not gonna pay this amount of money to the contractor, for example." Then that in itself, just the not payment of this amount, not following the decision of the dispute board, is in itself a breach of contract. Then the contractor can go, or whoever is on the other side, can just take this breach and go just this to arbitration. This is in itself is a breach of contract without even looking at the content of the disputes. there's the issue about the tricky issue of the legal enforceability. So you have a decision of the dispute board. So does it have legal enforceability? Yasmin, do you want to touch on this legal enforceability part in the MENA region?
I'm afraid I couldn't catch the question, but is it a general question on the enforceability matter?
Yes, I mean, enforceability.
We cannot hear.
Walid, if you could please restate the question, since we can't hear through the audio.
Okay, my question is regarding the enforceability itself. When it comes to arbitration, we have the New York Convention, so the decision or the award is binding by law, by the national laws. When it comes to the decision of the board, how it shall be enforced over the parties. For example, a certain amount of money needs to be paid, and the contractor or the owner refuses to pay. If it's an arbitration award, it might be enforced or applied by law over the assets of the other party. If the decision is from the board, how that shall take place? Thank
Okay,
you.
of course, I'll briefly answer. And Mian, please add anything from the Pakistani perspective as well. So as stated previously, okay, I'm coming from a continental law regime. And what we do is usually to put all the rules at a legislative level so that the parties will become bound vis-a-vis the courts, vis-a-vis the execution offices. However, at least in my country and in probably in the generality of this region, the dispute boards are not regulated by the legislative force. They are not in the law. That's why I was referring to them as contractual mechanisms. So they are only binding the two parties of the contract, the construction contract in this case. Therefore, any decision given by a dispute board will only be deemed as, let's say, to the maximum interpretation possible, as an amendment of the contract. So, as we all know that any party may choose not complying with the contract. So it will be in breach of the contract, the remedy for which is to initiate a lawsuit against such party, because there is no sanction that we can directly go and, for example, if that was a court decision, it will be very easy for the party who is requesting for that specific sum of money to put that court decision before the execution office in order to start an execution process, because it has that quality, the legal nature of being enforceable. But in dispute board decisions, we lack that legal nature, at least so far. Of course, as Mian was telling in his speech, some steps or some potential remedies are discussed in each country. For example, I can give some samples from South American regions, because there, even though a specific jurisdiction is of continental law nature, they put the dispute boards into their law in order to give the interim nature of being binding for both parties, the enforceability power. So therefore, to sum up, in case it is not regulated by law or by the legislative force, unfortunately, the dispute board decisions are not having the legal enforceability power. So if, for example, the employer failed to comply with that decision, it will simply be a failure of the contract. However, and that comes the non-legal but the practical aspect of it. For example, it has to comply with a dispute board decision, and that sum is going to be put in the next IPC for the contractor. And in case of a binding dispute board decision put in the IPC, not complied by the employer by not paying it, there will be, if it's not changed by the particular conditions, a suspension right for the contractor because a due sum is not paid by the employer. So there may be contractual mechanisms associated with it, but definitely, at least for now, there is no general legislation about dispute boards enforceability. Mian,
Mian, do you want to add something?
Thank you. Yasmin actually articulated in the proper manner about the inclusion in the IPC. I would like to refer to the United Kingdom jurisdiction, where adjudication is statutory. Just like Yasmin said, we need to have a governing law in order to get something enforced from the courts. So unless you have something in your national laws, you cannot get the decision enforced, which is why the example which I was giving with regard to Pakistan about the China Water Company, although that matter was then referred to the arbitration, but the arbitrator issued an interim award without going into that evidence procedure, because that decision of the dispute board was already in front of him. So he issued a partial award, which was then enforced by the Islamabad High Court in Pakistan, and that was one of the way to get that decision of the dispute board enforced after getting an interim award from the arbitration proceeding. The practical aspect you have already heard, and there are few jurisdictions, I think 3 or 4, that have statutory adjudication as part of their legal process. For example, in England, we have got 28 days within which the adjudicator has to decide upon the matter in any of the construction contracts, and once that decision is issued, that decision that can be taken to the court directly. So for those jurisdictions who do not have the shelter or the umbrella of a national law available to them, either the IPC inclusion is the route, or you have to go to the arbitration to get an interim award or a final binding award in order to get it enforced.
Thank you. I just want to add something
Waleed.
Yes.
I was just wondering if I could add one point to this. I know that we have a very large legal-oriented group here with us today. However, I do think that when we're discussing these issues of enforcement, which I understand are important to this audience, I just want to balance that with some of the statistics about the acceptance of dispute board decisions overall. As an example, the Asian Development Bank did a study of over 500 projects and found that 94% of all issues that were decided were accepted by the parties. Only 6% escalated on to arbitration. Other studies that we've done within the DRBF have shown as high as a 98% acceptance rate. So when we talk about this issue of escalating to enforce a decision because a party didn't accept it, we're talking about 2 to 6% of all decisions. And that's not including the issues that are resolved in the dispute avoidance section of the process, where the parties negotiate and resolve an issue before it becomes a dispute, perhaps with an advisory opinion or other methods of dispute prevention. So overall, you're really talking about a very small percent of issues that might be facing this legal issue. And so I wanted to balance out this discussion with those success rates, because I think it's a very important component when you're considering the efficacy of a dispute board and the value.
Thank you so much. And that beautifully delves into the point that I was going to make, is that a lot of people, and I mentioned your question about legal enforceability, is always commonly discussed in dispute board events, especially in the MENA region, because as Yasmin mentioned, the fact that the straightforward answer is no. In Egypt, for example, it's not legally enforceable. However, there's something, I mean, this is the purpose behind this event. First of all, like Anne said, practically speaking, a lot of cases do not go into arbitration, notwithstanding this issue of enforceability, because like we said, there's a practical consideration. These dispute board members are experts in this field. Most of them, the vast majority, are arbitrators. So it's like you're getting the arbitrator's viewpoint beforehand. So you have to review take your position again. Is this gonna, and the dispute board process, you have gone through statements and a hearing, and so unless you're and then you really know your position, is it strong or not? So, and you have to really consider, this is as we're saying, the value of dispute boards. And also, Yasmeen mentioned the amendment, and I want you to take note of that, because if you look at the sequence in the FIDIC contract, there's for dispute resolution. So you have the engineer's determination, you have the dispute board making a award or decision, you have what's called amicable settlement, and then you have arbitration. And this amicable settlement part is really important, because the philosophy is that, okay, so you went through engineer, you went through a dispute board, they made a decision. Now the parties have to really think about their positions, and if they reach an amicable settlement, as Yasmeen mentioned, the contractual mechanism is an amendment. Amendment, of course, is equivalent to a contract that's completely enforceable. And that is the notwithstanding the legal enforceability, this is the power of dispute boards, is that it can help the parties settle, even if they settle to something that is not in the decision of the dispute board. That's the trick. So a decision is made, a party objects, the parties sit down, they discuss, but now when they discuss, they have seen a report from experts. It's not just like the engineer alone, or no, these are arbitration experts and dispute resolution experts. They're going to look at their positions. They're going to say, just like the experience I said of Dr. Salim and me and Dr. Wiley waiting, and and then the contractor says, oh, we signed the settlement agreement. This is exactly what we mean. So it goes beyond the enforceability. This is the power. Okay, so let's take one more question. Can you get the mic? And if it's not working, then if you can answer ما في mic ثاني.
Well, referring to the point of enforceability.
So 1 sec. Can you guys hear? Can you hear him, Anne and Yasmeen? You can't?
Not really.
طيب معلش ممكن تيجي بس.
Well, referring to the point of enforceability, I believe that in Egypt, Qatar, and even in the UAE, we don't have a special system for the enforceability of such a decision. However, from a judicial point of view, I can see a characterization of such agreement as some sort of an agreement to the settlement of the dispute through some other a third party. And this per se can be agreed and can be enforced through an arbitral tribunal, even through expedited proceedings. And I believe this would be very important for the parties to decide the arbitration or the next stage that they might refer to in case they have such a decision, as an expedited proceedings would be very important to give an exequatur for such decisions through the New York Convention. So what I would like to ask for about the expedited proceedings and its usage in case that parties have such decision through their contract. Thank you.
I would like to very briefly mention that it is entirely possible. And I think Mian was mentioning in his speech about the fact that you can, you can, of course, bring a non-complied with dispute board decision to arbitration, and the arbitral tribunal will open it and, will review the merits and so on. However, you can also request an interim enforcement of the decision. Now, interim enforcement is what is very difficult in most of the countries, because we usually have the enforceability in case of the partial final awards, be it partial, be it the final award. So in that, the trick could be, as I think Mian mentioned, so when when the one of the parties does not comply with the dispute board decision, you can bring that non-compliance as a separate referral, and then you can only ask the arbitral tribunal to enforce that. The decision on that matter, even if they open up the merits and so on, will be final. And therefore, you may have a chance in enforceability. Otherwise, what would be proper is for that arbitral tribunal to give an interim award. I'm not sure about the enforceability power, and then continue the proceedings and open up the merits and decide themselves on the issue. So overall, there are some shortcuts. There may be some shortcuts to the enforceability matter. However, it doesn't really substitute the more practical way of putting that decision into like a tool of amicable settlement and enforce it through settlement kind of tool, as Walid was mentioning. For example, I have elaborated in the past the possibility for the dispute board decision to be signed by the lawyers of both parties. Because in Turkey, we have a specific legislation stating that any kind of document resolving a dispute which has the signature of the parties' lawyers has the exequatur power. So you can put it vis-a-vis the enforcement offices, and you can actually enforce it. So there may be some procedural tricks that, every country's, as per every country's legislative pieces. However, and of course, the arbitration is another way to enforce the dispute board decisions. However, it has its challenges as well, as the interim nature, opening up the merits of the disputes and so on.
Thank you so much. We've actually reached the end of the seminar, and we didn't even cover most of the questions that were asked. I'll just conclude with one more online question. In the hope that the CAI Regional Center does not impose on us liquidated damages for delay. So is it possible for Khalid Hassan is asking, is it possible for one of the parties that appointed the dispute board to challenge the dispute board member later on if circumstances exist that give rise to justifiable doubts with respect to the dispute board members' impartiality or independence, as one would do in arbitration? Who would like to take on this the answer to this question?
I've never heard of that scenario occurring. I don't know if Yasmin or Mian have.
I've heard.
Yes. Okay.
It's not a good scenario. So it emphasizes the importance of the extent of disclosure, of course. However, the DAA has the dispute provision. So any challenges will need to go through that provision. I mean, whatever it establishes, and it usually refers to ICC arbitration. So, just to remember that it is not granting a unilateral right to that party to terminate that contract.
Now, interestingly, this question is I've experienced this firsthand in the case that I mentioned to you several times, and I don't know how long I'll mention it until the end of my life. I always mention this case. In that case, the question says, is it possible for one of the parties? Yes, it is possible if there's justifiable doubts in the opinion of that party. Because notice in that question, there's justifiable doubts is in the opinion of a party. The other party might not agree to that. And what happened here is as I mentioned, the referrals were rising, and the awards were going to the contractor. And then for the at this point, the employer just said, okay, enough is enough. And they made a case that that there's a justifiable doubt as to the impartiality of one of the dispute board members. and they put that in writing, and that member started to you can imagine the scenario. Now it's getting ugly. So they start to respond to the employer, and there's back and forth, and that's why I mentioned this dispute board member at the end just terminated his contract. This is a very sad and unfortunate thing, but the answer to the question says, is it possible? Yes, it's possible, but there's a whole process, and of course that defeats the purpose of a dispute board. You know, if a party does that without solid grounds, then I think the party should understand that he or she is putting the project in jeopardy. It's like I've been in dispute board, you know, as a user. I felt the bitterness as a contracts person when I say, wow, this decision is not contractual. This decision is not fair. I can do all I want and complain all I want, but the thing is, it's not about me. It's about the project. So, and this is something that I've just realized later on, and that's why I'm a strong advocate of dispute boards. When you're thinking of the project, not yourself, not, you know, it's a different issue. So you want decisions to be made promptly so that we can go on, and then the project can be completed, and then, you know, and avoid the cost and time overruns, you know, and wasting everybody's time and money. So with that, I'd like to thank you all very, very, very much. To those who attended in person and online, I can't thank the speakers enough for your valuable contributions. I think it was very, we're talking about the value of dispute boards, and these were valuable contributions. So thank you so much. And we hope to see you again in future events. Thank you.
Thank you very
Ali.
much.